I'm joined today by Bert Newborn, who is professor of civil liberties at NYU Law School, former legal director of the ACLU, and also author of the book Madison's Music on reading the First Amendment. The First Amendment is, if you're at all discussing politics in 2015, so relevant, and you've been looking very closely at what the First Amendment actually says. It's not clear that everybody is doing that recently. So let's start there. What does the First Amendment say? What doesn't it say also?
Well, in fact, the First Amendment consists of 45 words. Nobody ever, and including the current Supreme Court, ever tries to read all 45 words at once. What they do is they pluck a couple of words out of the text, like the Free Speech Clause, which is 10 words, or the Press Clause, or the Petition Clause, or the Establishment Clause, and they read them as though they were self-contained documents, and they hold a couple of words in their hands, and they think that they're getting the full meaning of the text. I'm urging people to remember that the text is 45 words long. It's not just a couple of words long, and you would never read a poem by tearing a couple of words out and thinking you were getting the poem. You would never listen to a great piece of music by listening to a couple of notes and thinking you were getting the whole piece of music. And I think we've made a terrible mistake by cannibalizing the First Amendment into a kind of several different pieces of turf that don't seem to have any connection with the rest. And I urge people to read the whole amendment. And if you read the whole amendment, there's a remarkable story there.
And tell us about, now that you have put so much time into looking at those 45 words and looking at the history of those 45 words, how should the for the layperson, what's the accurate understanding of the First Amendment?
Yeah, the important thing in my book, I mean, to the extent the book has anything important at all, it's that lay people can read the First Amendment just as well as judges. There's no magic in that text. There's no special license that lawyers have to know what the true meaning of the First Amendment is. The words are there for us all to read. And the important thing to remember is that the First Amendment is made up of 6 ideas. It's the only time in our cultural history that those 6 ideas have ever been listed in a single document. When Madison was working on the First Amendment, he had 42 documents that he was looking at, 42 source documents that he was looking at, ranging from the Magna Carta way back in 1215 through the English Bills of Rights, through the colonial charters, through the Revolutionary Bills of Rights. None of them had anything like this remarkable organization. And this is what Madison did. He starts it with the Establishment Clause and the Free Exercise Clause, 2 clauses. Establishment Clause is freedom from religion. You've got to remember that the first thing in the First Amendment is freedom from religion. It prevents people from shoving their religion down your throat. Secondly, free exercise of religion, the ability to exercise your religion free from government compulsion. Now, to put the two of them together, and what Madison was working on was conscience, freedom of conscience. He wanted a 3rd clause that would protect secular conscience. He couldn't get it through the Senate in 1789, but the Supreme Court has put it back in through a kind of word magic. So when we look at the first 2 clauses now, the Establishment Clause and the Free Exercise Clause, we have freedom of conscience. And if you want a democracy, that's where a democracy has to start. It starts in the free thought of a free citizen. Now, once that thought generates an idea, the next thing you need in a democracy is the ability to articulate the idea. So it's no coincidence that the Free Speech Clause is 3rd. It comes after the 2 conscience clauses. So once you enunciate an idea in your free conscience, the Free Speech Clause allows you to speak. But speaking is not enough in a democracy. I hope I'm going to reach more people on this program than I will be able to speak to personally in my whole life. So that Madison realized that you need a 4th clause. And the 4th clause is a free press clause to be able to magnify your speech, amplify it, and allow it to reach a mass audience. And then he said, hey, after it reaches the mass audience, what's the next thing that democracy needs? Well, the next thing that democracy needs is the right to free collective action. Once you have a freely expressed idea that has been spoken under the speech clause, disseminated to a mass audience under the press clause, the next thing is to organize around it. And that's what freedom of assembly is. Freedom of assembly is the freedom to take collective action in support of a democratic idea. And it couldn't come anywhere else. It couldn't come before speech. It couldn't come before press, because you can't have collective action until you have mass dissemination of the idea. And then finally, after mass dissemination of the idea in the collective action clause, you then have the petition clause, which is the right to take that idea and bring it to the authorities, to the legislature, to the president, and require them to act on it one way or the other. So when you think about it, the First Amendment is a story of the life cycle of a democratic idea, beginning in the free conscience of a free citizen, freely articulated, disseminated in a mass basis, organized around through assembly, and finally presented to the government for petition. And every single word is exactly where it should be. And if only we would read it as this wonderful poem to democracy, there's no way that we could read the First Amendment the way the Supreme Court does today, to essentially let the super rich control democracy. What the Supreme Court has done is torn the free speech clause out of the heart of the First Amendment itself and used it as a mechanism to say money equals speech. Therefore, any amount of spending is protected by the First Amendment, even if it completely undercuts the ability to have a fair, robust, egalitarian democracy. And so what the court has done is it's turned the First Amendment from being democracy's best friend, which is what Madison was trying to create, and has turned it into a bad parent. It's turned it into the free speech clause polices democracy. It disciplines democracy. It prevents democracy from working, even when the law itself is designed to allow democracy to work. And my hope is that if people take a look at my book, if they're persuaded that there is a story, a wonderful poem in that 45 words, that they will realize that you have to construe the amendment as democracy's enabling force, the thing that makes democracy work, and not as some sort of device that makes it harder for democracy to work.
And I think one of the ways in which calling it a device used sometimes for personal or political gain is the way that free speech and the First Amendment have been misused colloquially in recent history. I'll give you a couple of examples that really represent this misuse or misunderstanding. One is there was this radio host, Dr. Laura, right? And she used the N-word 11 times on the radio while working for a private employer. Her audience was offended. She did not renew her contract and said she had to go elsewhere to regain her free speech First Amendment rights. This, to me, epitomizes such a fundamental misunderstanding of what we're talking about. It doesn't involve the government, first of all. And number two, correct me if I'm wrong, freedom of speech, even when we talk about the government as the sort of arbiter of whether you have that freedom or not, freedom of speech does not guarantee immunity from the consequences of that speech, based on my reading. You tell me if you disagree.
Well, no, sure, of course, David, that's right. I mean, what the current Supreme Court has done, and what a lot of people do, is they completely ignore the fact that there are all 45 words in the First Amendment. They take the 10 words of the Free Speech Clause, which says Congress shall make no law abridging the freedom of speech. So they then take the freedom of out, because after all, the freedom of doesn't have any literal meaning. What does the freedom of mean? It means what we say it means. It's a man-made concept, and somebody has to decide it. So they throw that away because that gives you a headache. It's too hard to think about. And then what they wind up doing is saying what the Free Speech Clause says is Congress shall make no law abridging speech. And then you get a radio host like that who says, well, it says Congress shall make no law abridging speech. Somebody abridged my speech, therefore something terrible happened. But that's not what the Free Speech Clause says. First of all, it says the freedom of speech, which means that you don't have a right to threaten people. You don't have a right to extort money. You don't have a right to engage in false advertising. There are limits because it was not part of the freedom of speech. And then they ignore the fact that hearers have rights too. The reason we protect free speech is because of the dignity of the individual. We think that everybody's dignity means that they should be able to express themselves. And I agree with that. I didn't serve as legal director of the ACLU because I didn't believe in the dignity of everyone to express themselves. But I think hearers have dignity too. And targets, the people that the speech is about, they have dignity also.
Well, along those lines, I'm curious what you would think of, with all the discussion now of so-called religious freedom bills. What happens when you have conflicting religious freedom? For example, if you have Christians refusing to serve Muslims because the Christian believes that his religious freedom allows him to turn away whoever has religious beliefs they disagree with, but the Muslim also may be discriminated against based on their religious beliefs. What are the limits of that?
Well, David, that's an important perception because this isn't new. I remember when I was a young civil rights lawyer working in the South in the 60s, one of the arguments that the segregationists made was that they had a religious right to refuse service to blacks. And that it was therefore a violation of their religious rights to say that blacks had a right to come into the store or to the amusement park or to rent from a landlord, and we overrode that. We said that's ridiculous. Nobody has a First Amendment right to treat someone else unequally because the fact is your freedom of religion stops at the point that you use your religion to shift real costs to a third person. And that's because the Establishment Clause is there. The reason the First Amendment starts with the Establishment Clause is that Madison realized that there should be freedom from religion. You cannot ask the government to take your religious beliefs and pound them into somebody else. So that you cannot ask the government to say that you have a right to say that you won't serve gays, or that you won't serve blacks, or that you won't serve Muslims, or that you won't serve Jews. If you open up a place of public accommodations, and there's a law that says you have to serve everybody equally, there's no religious defense to that law. Because the moment there is a religious defense to that law, what you wind up with is saying that you can ask the government to impose a defense on a third person and make that third person bear the costs of your religious belief. The Free Exercise Clause is all about enjoying the free exercise of religion when it doesn't shift the cost to anyone else, when you bear the costs yourself. But you don't have a right under the First Amendment to run around and use the religion clauses as a club to beat someone else and say, I can make you endure the costs of my religious freedom.
Well, it's very clear, particularly given what is going on in the last few weeks. Very important discussion. There's so much more to talk about, and we will have to do it next time we have you on. We've been speaking with Burt Newborn. I'll remind you, the book is Madison's Music on Reading the First Amendment. Could not recommend it more highly. So relevant today. Thanks so much for being on with us.
Thank you, David. I enjoyed it.